Hello, this is Matt on the Moon Lambo channel. We have Bill Hinman's emails. Yes, we really do, except they're heavily redacted. Now, although this is indeed the case, heavily redacted emails, which were obtained by an XRP community member through a FOIA request, even though they're heavy redactions, doesn't mean that there wasn't anything to find. And I'll tell you, some of you may have seen the very last video I put out where I was talking about a topic that Attorney Deaton brought up on social media, on Twitter specifically. Like, why not just sue Bill Hinman now? With all of the evidence and the appearances of impropriety, why not sue him right now and get to the bottom of this, and his, monetary gains, let's say, as a result of the Ethereum free pass speech, all this stuff. Why not just do it now? Well, I don't want to rehash that whole video, but I will say, one of the points that I brought up was that what we need to find, really what we need to find before suing Bill Hinman, is proof that he did know that his firm, his law firm, Simpson Thacher, was a member of the Enterprise Ethereum Alliance. Because if you can prove that, it's no longer a question of just an appearance of impropriety. That's some serious, real impropriety right there. So the thing to find is just that. Is there any proof out there that he did know? Well, we've got some names and additional information as a result of this, although you'll see it's comical the degree to which this is heavily redacted. This document's 71 pages. But even so, we did get some new information. We've got some new paths that we can go in terms of researching, digging further, as the XRP community has been doing. So I'm going to be sharing with you the latest on that. And also, I want to give you an update on the SEC versus LBRY case, because that's going to be ending before the Ripple case ends. And to some degree, that's going to potentially impact what happens in the Ripple case. So I got comments from attorney Jeremy Hogan on that. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so news of the Billy Boy Hinman emails getting released. This news broke 2 days ago, May 4th. And ProCoin News tagged me along with a number of others in the community, so thank you very much, ProCoin News. I do appreciate that. And I'm going to run through this, make sure everybody's caught up to speed, and then we'll get to some of the stuff that we've found to this point and exactly why this is so important in getting to the truth of whether or not Bill Hinman actually did something illegal. And so here is the initial article from 2 days ago from ProCoin News, titled "Breaking: FOIA Request Granted, We Have Bill Hinman's Emails." It reads as follows. A huge shout out goes to Stuart Young for this one, as that's the member of the XRP community that filed the FOIA request. After months of fighting for a Freedom of Information Act, or FOIA request for short, made to the SEC originally back on January 2nd, 2022, he was finally successful in receiving a response, and we have all of the documents. Stuart forwarded the documents to us so we could get them out to you. So we published these with his express permission. We also note that items received in a FOIA request are public domain. Now let's get into the meat of what we've got here. Stuart's FOIA request asked for 3 items. Number 1, access to Bill Hinman's public calendar. 2, a list of the 63 email recipients he discussed the Hinman speech content with. And 3, any official SEC meetings Jay Clayton had with Ethereum. And amazingly, today, he finally received a response. And then here's the cover letter. I don't feel the need to read through it, but if you want to see the cover letter, you can hit pause here and you can read the whole thing right there in all of its glory. So again, and amazingly, today, he finally received a response. Here is the letter back from the FOIA Services Department of the SEC. Moving on, here we go. This is just the cover letter, but found so many things interesting here. First, they've come up with several justifications for why they have to redact information, and redact they do, as you'll see in a moment. But here was my favorite part, their response to request number 1, which was a copy of Hinman's public calendar. And what he ends up pointing out here is that they're not ready to give the public calendar. Folks, this is a public calendar. What is super duper or top secret about this that needs to be held back for any sort of reason whatsoever? It's complete. So they're still working on it. They wrote the following. We are consulting with other SEC staff on item 1 of your request regarding Mr. Hinman's calendar. As soon as we complete our consultation, we will notify you of our findings. So, okay, that makes no damn sense on the planet, but okay. Now, point number 3, they actually did comply with. They said that the a list of meetings with Jay Clayton. It's all on the SEC website, and they provided a link. So then there's just the question of the emails remaining. And folks, you might want to look at your screen for this one. This is absolutely absurd. So here it is. There's 71 pages. Let me just start kind of going through here. And you can see the parts blocked out in pink here have all been redacted. So I'm just going page by page by page, redaction, endless. It's just a veritable cornucopia of redaction. And you get a redaction, and you get a redaction. Everyone gets redactions. And why? Because reasons. Because reasons, folks. So, while that is admittedly a bit of a disappointment, there are a lot of names on these lists. And you know what the XRP community does. The XRP community, you know what we're going to do. Work collectively to research every single one of these names and find any possible ties. And if there's any sort of evidence out there that's just been hard to find at this point, if there's some sort of new link to be found, you know that it's going to be uncovered by the XRP community. And again, the holy grail, as I cited earlier in the video, we need to find that Bill Hinman did know that his law firm, Simpson Thacher, was a member of the Enterprise Ethereum Alliance at the time that he was given his Ethereum free pass speech. If you can prove that, he's in serious trouble for reasons that I cited in my very last video. I don't want to rehash that, but that's the holy grail. That's what we're actually looking for here. And so some of the stuff that was found here, there's an individual from the community named Crypto Arsenal who put a list together of the names already. Look at this. He wrote the following. Right. I think I have all the names now from the Hinman speech emails. 38 people involved in what is described as a personal opinion. 38. Now, folks, given that the judge has determined that this was indeed not official SEC decree, but it was just Billy Boy Hinman's personal opinion, why the hell were 38 people from the SEC working on it? And here's the list that he's put together. It's completely absurd. Now, the good news is, of course, since the judge did find that this is Billy Boy Hinman's personal opinion, they can't claim privilege. So that's the reason that we're supposed to get, and Ripple should get, all of the emails unredacted. And unless there could be a couple of exceptions here and there, but all the emails associated with that, the judge has already ordered. You're going to get it unredacted. So, silver lining, right? I mean, that's actually a big one right there. Ripple CTO and co-creator of XRP and the XRP ledger itself, David Schwartz, responded to this story as well. And he tweeted out the following. Wow, such shocking revelations. I mean, did you see this? And he shared this screen grab with a bunch of pink boxes because it's just redacted information, right? So he's being sarcastic because the SEC is being ridiculous with how much they're redacting. And then in a separate tweet, he wrote, I'm sorry, I'm going to have to delete that tweet. Apparently, they inadvertently failed to redact a piece of punctuation. And that's what he's referencing right here where I'm circling. Let it not be said, David Schwartz does not have a sense of humor. Then there was this from my fellow XRP YouTuber, the Digital Asset Investor. He shared this screen grab and wrote the following. The SEC and Bill Hinman have lied in court and told a judge that the Ethereum free pass speech was Bill Hinman's personal opinion. What judge on earth would this not piss off? And folks, think about it, because there's a huge list of people that were included on this. Again, the total number, assuming Crypto Arsenal counted correctly, and I don't have any reason, wouldn't have 38. But it was just personal opinion, right? And then there was this from attorney Jeremy Hogan on this topic. He said, one thing I saw in the cover letter is that information, quote, prepared in anticipation of litigation, end quote, is listed as one basis of redaction. What upcoming litigation could it be? Kick? Telegram? LBRY? No, or maybe, just maybe, it was XRP that was referenced. Yes, indeed, quite curious there. But, in the litigation front, we're going to have, it's going to be super duper interesting when this comes down. We're going to find out what happens with the SEC versus LBRY case, another cryptocurrency, LBRY credits, LBC. We're going to find out what happens with that sooner than later, certainly quite a bit before the conclusion of the SEC versus Ripple case. And this it will have, to some degree anyway, an impact. Because, and here's why, if the SEC wins, they will cite this case moving forward, so it would be, quote unquote, considered by the judge It doesn't mean that it would be binding, so I'm not saying that this would result in binding precedent, but circumstantially, it's just something that you'd still be able to look at and say, hey, court, you need to take a look at this. Judge, look at this. This is something that should be considered. Not that it's going to be detrimental. I think I'd rather that not be the case. You know, I'm very optimistic with what's happened with the SEC versus Ripple case at this point, at least what we're publicly aware of all the pretrial stuff. But this does throw another question mark in the mix. Not that it's necessarily going to be huge, but I don't know that for sure. None of us do. It's just another moving part in all of this that if we could magically avoid, I would prefer that, frankly. And so anyway, shout out to attorney Filan, member of the XRP community, for sharing this. And he simply wrote, the SEC versus LBRY case, the SEC has filed its motion for summary judgment, and it's below. Now there's a section of this legal document that was shared by attorney Hogan. I'm going to read a portion of it, and then I'm going to share with you what Jeremy Hogan had to say about this. So this was the summary from this is written by the SEC regarding the LBRY case. Here's the summary. Here's what they wrote. LBRY Inc. is a fairly ordinary software company. It makes web and mobile application software primarily used for viewing videos. LBRY's claimed difference is that it uses a blockchain to enable its video sharing and related services. Instead of relying primarily on stock sales or venture capital to raise the money to develop and operate its business, LBRY created a digital asset called LBRY credits, or LBC for short, that it then offered and sold to get operating capital. LBRY formed investment contracts by the way it offered and sold LBC. Investment contracts are a type of security, and by offering and selling those securities without filing a registration statement, LBRY violated Section 5 of the Securities Act of 1933. So here's what attorney Hogan had to say about that. If you hold XRP, pay attention to the SEC versus LBRY case, which involves many of the same issues as the Ripple case and will be decided first. This summary judgment from the SEC is its template and continues its strategy of downplaying the uniqueness of blockchain projects. The LBRY/Ripple cases will hinge on the ability of the judges to understand that issuance of tokens operating on a decentralized ledger is not just another way of raising funds and does not implicate the disclosure requirements underpinning the reasoning behind securities laws. Exactly. The SEC refuses to acknowledge that utility exists thanks to cryptocurrencies. They absolutely flat out refuse to acknowledge that. And you know, even if LBC had been registered, my gosh, that destroys the utility. Because think about it, with a decentralized system, you can't even track everybody that's buying and selling, which, as it turns out, is a requirement anyway. So I don't know if you'd be able to successfully register anyway. But even if you could, what you as an entity, LBRY, is going to be able to track all of that moving forward. And that's what about what happens on secondary markets? Like you don't have that type of control. That's not how any of this works. And so, in a controlled system, utility's dead. It just is at that point. But the SEC just doesn't care. They'd rather just have the entire asset class destroyed within the United States. As long as that means they get to have their power over it, they don't even care. And then there's this tweet from somebody named Let Her Ripple, who caught something here in this document from the SEC. They cite that there are 3 prongs of the Howey test. Now, folks, if you've been following this case for any length of time, you know that there are actually 4 prongs of the Howey test. The SEC is pretending that there are only 3. Which one are they throwing out? And I first saw this tactic dating back to August or September of last year when SEC Supreme Leader and Dictator Kim Jong-Gensler was being interviewed at, I think it was the Aspen Security Conference or something. That might not be the right name. It was Aspen something or other, Security Forum maybe. And I highlighted this at the time. I watched his interview, and he said that the Howey test, it's a 3-form test. And then he went on to name the prongs of the Howey test, leaving out common enterprise. I kid you not, just making stuff up. And so now here you have the SEC attorney saying that there are 3 prongs of the Howey test. Completely absurd. Grinds my gears, folks. I'll wrap up there, though. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. So that would be a very, very, very bad idea. Until next time, to the moon, Lambo.